So you're headed into mediation and you need to know what to do to properly prepare. For one, I want you to breathe easy because mediation is a great time to explore alternative solutions to the problems that you're facing in your divorce or custody situation. And it's normally done outside of the presence of your soon-to-be ex with a neutral and your attorney. So you get lots of downtime, lots of discussion time. But the key to success in mediation is to prepare in advance. We don't use mediation as a time to explore what our proof is or to explore what our financials are. All of those things have to be prepared in advance. All of your financial disclosures should already have been, exchanged and examined. A proposal for a separation agreement should already be prepared by your attorney. Parenting plan, down to every small item, should be prepared so that you can make proposals, global proposals, and get your case done. It's at that point you're going to find out where the problems are, like the points where you don't disagree, and you can use that time to negotiate a settlement. In fact, I prepare for mediation just like I prepare for going to court. I mean, absent, actually doing formal exhibits, but I have soup to nuts, all of my positions well documented, substantiated by case law so that I know if I get pushback on any of them, I've got arguments that I can present through the mediator to the other side to persuade them that if we don't reach an agreement, then I'm ultimately going to prevail if we go to court. That really is the best use of mediation. Mediation oftentimes is scheduled, for a short period of time, like as a block check. I caution you against doing that. Quite frankly, what you're doing by treating mediation as a block check is you're taking the power out of your own hands to determine, what it is you want to happen in your case, and instead putting it in front of a person who has thousands of cases to hear a year, who knows very little about you and your family, to make snap decisions based on just a snapshot of information. Mediation is a fantastic tool for cost-effective, mutually beneficial agreements. Now, you're going to have to give. That's the nature of compromise. It's where nobody gets everything they want. But hopefully you'll come up with an agreement that you can live with, and that would be the best outcome. If you want to make the most of your time in mediation, you'll want to communicate effectively. And by that, I mean you'll want to talk about your positions, where your red lines are, and what you're willing to do. You don't want to go in there and use the time as a therapy session or a time to begin to discuss with your attorney what you're wanting to do. It really is a matter of, okay, here's where we are. This is what we offer. Okay, next point. Here's where we are. This is what we offer. And you go down essentially, a list of things, identifying where you're in agreement, finding where you're not in agreement, and then begin to work through those parts where you're not in agreement to see if you can get those resolved. If you prepare well, and the other side does as well, it's a very realistic expectation that you're going to come out of mediation with a lot of agreement. Maybe not a global agreement. You will have identified maybe some sticking points. Maybe you can narrow issues that you may need to continue to negotiate, get more information on, or ultimately have to go and take to the court to get them resolved. But mediation should get you realistically lots of point of agreements and highlight for you the remaining disputed issues, which should narrow the amount of time that your attorney has to spend working on your case and maybe eliminate the need to move forward in litigation at all. If you have any questions about mediation, feel free to give us a call at Brighter Day Law. We'll be happy to help guide you in putting together a plan, guiding you through mediation, and hopefully getting you done collaboratively.